Good morning, members of Senate Judiciary Committee and the public joining us here on this Friday, February 18th, finalizing our first week of the 2022 budget session of the 66th legislature. It's good to see all the warm faces here in the room and a full membership of the Senate Judiciary Committee. And with that, we'll start with roll call.
Senator Cooper.
Here.
Senator French.
Here.
Senator Kolb.
Present.
Senator Cross.
Here.
Chairwoman Nethercott.
Here. All right, I hope everyone is enjoying a little bit of a late start at 8:30 this morning due to our long evening last night and what is anticipated to be another long day today. So just kind of signaling to everyone in the audience and just how busy this first week of a budget session always is. So hopefully everyone has got that little extra rest in and we're ready to do some good work this morning. And with that, good Senate members, we will do Senate File number 26, District Judge Positions Authorization and Funding. So good senators, we saw the same version of this bill earlier this week in Senate File 25, but did not have the appropriation in it. We have heard the testimony on this bill, and I believe we have full Senate committee support for advancing these three new judicial positions, including with the appropriation. We just want to go through and hear from the Senate members any concerns or conversations about the fiscal impact on the appropriation to this particular bill. Give you a minute to look it over. And any comments from the committee members? Yeah, Senator Kolb.
Thank you, Madam Chair. Just to help out the general public, during the summer, there was data given to us that weighed all the court load across the state for these positions. And it was justified by the numbers. Even I'm a person who's doubtful of numbers, but frankly, the way we judge everything, the metrics showed that this was necessary. So even if you don't quite believe all the numbers, believe that the workloads are what they are, and justice delayed is not justice served. And I think everybody deserves a day in court in a speedy trial, and this will greatly help that. And yes, it costs money, but justice for people is going to be a certain expense with that. And I think it's what we need to do to protect the people and give you your day in court. I'd just like to share that with my co-committee members and the audience. Thank you.
Any further comments from the committee? All right, I will direct the committee's attention and those in the audience to the fiscal note of the bill. And that's where I'd like testimony to focus on, both for the committee for questions and members of the audience. With that, Ms. Butler, I see that you're in the room. Do you have a copy of that fiscal note? Do you feel prepared to come forward and talk to us maybe about it?
That sounded like a yes.
Yes. She's exuding confidence this morning. Welcome, Ms. Butler. If you would introduce yourself to the committee, and then I have some questions for you.
Good morning, Madam Chair, members of the committee. My name is Elisa Butler. I'm the State Court Administrator at the Wyoming Supreme Court.
Ms. Butler, thank you. When we look at the fiscal note, because we know that our Senate colleagues, if this bill comes out, are going to have questions about it, and they're going to focus in on this fiscal note. And so just making sure the committee is fully apprised and we have a full discussion and dialogue about it. So it reads, this bill contains appropriations totaling $2,235,200 from the general fund for two new district court judges and related staff costs in the 3rd and 7th judicial districts. This bill contains an authorization for 8 full-time positions, 4 positions, including the new judge for each district court. So that's what we'll really be defending on the Senate floor. And so walk us through. The bill says 3 new judges, and Senate File 25 said 3 new judges. So why is this appropriation in this fiscal note just for the 2 new judges?
Madam Chair, that's a very good question. And so my understanding, and again, I haven't been around for too long, but my understanding is there was a situation a few years back where a judge was appointed in a judicial district, and there was not quarters suitable to house that judge in that county. And as a result of that, what the legislature has decided to do moving forward is to require that the Chief Justice certify that there are suitable quarters for the judge before that appropriation is given. So in this bill, what you're looking at is a new judge and 3 new judges and appropriations for 2 of those 3, because in 2 of those judicial districts, the quarters are available and ready for those judges right now. And those 2 judicial districts are the 3rd and the 7th. So in the 3rd, the judge would be housed in Evanston. In the 7th, obviously, the judge would be housed in Natrona County.
All right, questions from the committee on this point? Yeah, Senator Kolb.
Thank you, Madam Chair. Is this the average cost for judges, or is there a startup cost associated with new judges? Could you expound on how you came up with these costs?
Madam Chair, Senator Kolb, this is the standard budget for all of our district court judges. So the budget that you see there is the standard budget. The startup costs, there are some. Those are generally borne by the Supreme Court's budgets. So there are things like computer equipment that we provide to the judges. And so there are some of those. They generally will come out of our general budget at the Supreme Court or the special revenue fund of the Judicial Systems Automation account.
Thank you.
Senator French.
Thank you, Madam Chair. Just if you expand a little in the 3rd district where that's going to be housed, you said it's ready, the 2, Natrona and in Evanston. Is that, what is that, a building down there, or is it something that the judge has been using when he comes? Expand on that if you would, if it's why it's ready to go.
Ms. Butler.
Madam Chair, Senator French. So right now in the 3rd judicial district, Judge Blumel, and he may be here to testify if you would like to hear from him. Judge Blumel travels between Kemmerer and Evanston, and he hears cases in both of those places. And so there is a suitable courtroom both in Evanston and in Kemmerer, and he uses them when he travels. So that is an existing space now. In Natrona County, when they built the new Justice Center there, they actually built it with the idea that they would get a new judge there at some point. So they built in an extra courtroom and chambers in that new Justice Center when they built it in Natrona County.
And Ms. Butler, when you say they built it, who is they?
Madam Chair, my apologies. It is the county. The county bore those costs. The courthouses themselves are county buildings.
Correct.
So those county commissioners approved that.
Madam Chair, that is correct.
Eminently a good choice.
A good choice. Senator French, any follow-up?
Yes, Madam Chair. I know this bill doesn't pertain to it, but it will in the future for the 6th district. Apparently they don't have the proper space or the space. But so is that something that's coming down the line in a year or 2? Well, it'd be a couple of years for appropriation for that. And the space that's suitable.
Madam Chair, Senator French, I believe they are working on that right now.
Okay.
So yes.
Okay, thank you.
Yeah, Senator Kolb.
Thank you, Madam Chair. The IT costs. What is the current state of affairs with the agreement for IT support locally? Do you have you expound on that?
Sure, absolutely. Madam Chair, Senator Kolb. So the costs of technology in the courts throughout the state is borne by the Wyoming Supreme Court. Generally, I will say the counties, there is a statute, and I can't name it off the top of my head, but there is a statute that requires the counties to basically bring the infrastructure up to the wall. So things like pulling of cables and network and all of those things, that is the responsibility of the counties. Outside the wall, it's all up to the court, the judicial branch, to pay for those costs. So things like courtroom technology, that's all borne by the judicial branch.
Follow-up?
Local IT support. I'll say that I know in Sweetwater for a fact that are the county IT folks that are actually employed by the county board of county commissioners. actually give support locally. So they don't have to have somebody with the state say, come out on the site. So they do more than just bring it up to the wall outlet. And then, so they have a really good working relationship. I'm just saying there is a cost with that that's borne by the counties.
Madam Chair, Senator Culp, that's absolutely true. So what I will tell you is we have our IT staff here in Cheyenne that supports the entire branch, has a really good relationship with most of the IT staffs around the state. And so if there are certain things that can be done, we work in close coordination with them. The other piece of that is the clerk's offices, the district court clerk's offices throughout the state are entirely supported by their counties. Their IT, aside from some of the software that the judicial branch provides, all of their IT is provided and supported by the counties themselves.
Any further questions for Ms. Butler? Stay close, Ms. Butler. We'll work through this fiscal note a little bit more carefully, but I think in order to digest it, we'll just take it piece by piece. And Judge Blumel, I saw, is on. Judge Blumel, if you can start your camera in between court hearings. Judge Blumel, good to see you again this morning. You heard Ms. Butler testify and provide us some explanation as to the location of the courthouse in your judicial district. So if you could maybe walk us through that a little more thoroughly and explain your travel commitments and time constraints concerning just that windshield time associated with travel and roads and those challenges.
Thank you, Madam Chair. Members of the committee. I live in Kemmer. I've lived in Kemmer since I graduated from law school, and I have served over here in Uena County as well as Lincoln County since I was on the bench. Lincoln and Uena County, particularly Kemmer, Evanston, Bridger Valley, are all kind of one little area, shall we say, a market in the legal area. And it takes an hour, a little bit less than an hour, but I figure an hour to drive from Kemmer to Evanston or vice versa. I currently roughly schedule 3 days a week in Evanston, 2 days a week in Kemmer, and then that changes as I've provided testimony before. I have, as a result of that, 2 speedy dockets that I have to keep. I have speedy dockets in both Lincoln and Uena County that I have to keep, which is all the criminal, all the juveniles, all the private road, termination of parental rights cases. And as a result of that, those burdens not only become compounded with the driving of roughly 6 hours a week, but they also become compounded in trying to schedule time in the courts with just me. I've got facilities in both Evanston and Kemmer. And to actually give you history, if you wish for it, Madam Chair and members of the committee, is Judge Troughton, when the Uena County Courthouse was remodeled in the 80s, Judge Troughton made Evanston his primary spot for the 3rd Judicial District over here. When he retired, Judge Sanderson also continued that. When I came in, since I lived in Kemmer, Judge Sanderson was from Star Valley. He ended up buying a place over here in Evanston. So I don't know if that answers the committee's questions, Madam Chair. If anybody has any more details they'd like from me, I'll certainly provide it.
Questions for the judge? Senator Culp.
Good morning. Thank you, Madam Chair. Could you expound on the issues with weather? I drive that road and I find it rather treacherous at times. And certainly, you do take your life in your hands just because of traveling in Wyoming. And I thought maybe you could talk about that.
Madam Chair, Senator Kolb, thank you very much. I do deal with weather. I'm born and raised in Wyoming, and I've become a little more conservative in my winter driving than I was in my younger years. We do have the ability, if I-80 is closed with, as Senator Kolb, and many of you probably do, there are what we refer to as the 3 sisters in Uena County, Bigelow Bench. There's the one near Leroy, and then there's the last one. And I have to go over the last sister from 189 into Evanston and vice versa. It seldom gets closed, and usually with, frankly, the Department of Transportation has a wonderful program that if I can get to the gate without the semis blocking me getting to the gate from Evanston to come back home to Kemmer, I can usually go ahead and drive that unless there's a wreck on the First Sister. Alternatively, I have what I think this year it's only been twice. I've gone through Randolph and Woodruff to go back and forth. And yes, I can do court remotely, but as all of you know, and thank you for allowing me to appear by video today, there's something lost in doing video as opposed to live. And the other part is I'm still old fashioned in that I still like having the hard files to refer to when I'm dealing with cases. But that is a factor. It's not significant, and at least I don't find it that significant. I did at one time ask for a state car, but frankly, when the Joint Judiciary Committee passed this budget item and all of that, I withdrew my request for a state car. I think I probably am the judge that uses my private car more than any other judge in the state. That may include even circuit court judges, but Ms. Butler certainly and the staff at the Supreme Court would know that more than I. Senator Kolb, I hope that's been responsive. Any other questions, Madam Chair, Senator Kolb, or other members?
Senator French.
Oh, thank you, Madam Chair. Judge, so if that additional judge is funded for over there in the third, since there seems like maybe more caseload in the Evanston area, since you spent 3 days down there and 2 in Kemmer, will you, in the additional judge, if it's authorized, 1 in Kemmer and 1 in Evanston, or at times both of you in Evanston possibly and Kemmer possibly?
Madam Chair, Senator Kolb or Senator French, thank you very much. The facilities are, and so to kind of again, and Senator Kolb probably is aware of this, but Sweetwater County actually has 2 courtrooms, and then they have a small courtroom. There are times that my courtroom in either Evanston or Kemmer is occupied, and the counties have been more than generous in allowing me to either use the commission chambers for hearings with court commissioners, and then the circuit courts also work very closely with the district court and vice versa. So Senator French, members of the committee, that is certainly a possibility. And the other part that if you look at the numbers, and I've worked closely with my colleagues, Judge Lavery and Judge Robinson, that should there be a 4th judge placed here in Evanston, not only would I be able to assist in Evanston and the Evanston judge assist in Kemmer, but there would be the ability to assist in Sweetwater County with what has typically been referred to as the small courtroom off of, frankly, off of Judge Lavery's chambers. So I don't know if that's responsive, Senator French, but this just gives so much more leeway to the bar as well as the members of the public to actually get their matters heard in a timely fashion.
All right, knowing you have a 9 o'clock, Judge Bumel, heard your calendar ding. Make sure we'll wrap this up quickly. Any final questions for the judge? Any final comments, Judge?
Madam Chair, one last thought I'm having, and maybe this is also responsive to Senator Kolb and Senator French. One of the things that I have done, and frankly, with the growth that we're having in North Lincoln County, and also the anticipated growth with Terra Power coming in to Kemmer area. Right now, for my speedy docket on my criminal stack, I have a criminal jury trial set in Evanston every month. I have been able to finagle that, probably not a very good term, but it's a real term for me, so that I have my criminal jury trial stack every other month in Kemmer, and my criminal stacks are usually between 15 and 20 in each of those places. So in Evanston, I'll have roughly 15 or so criminal jury trials each month stacked, and I will have 15 to 20 in Kemmer every other month. And I fear that with Terra Power coming, and also with the growth that is, I think all of you are aware of up in North Lincoln County, that is becoming problematic and difficult for me to move things along. Thank you, Madam Chair and members of the committee. If you have any other questions, I will be at your disposal.
Thank you, Judge. Appreciate having you here this morning. Ms. Butler, any comments to follow up on that?
Madam Chair, I don't have anything else to add unless you all have additional questions for me.
Let's keep working this fiscal note. I know this will be the heavy lips. I know. I think you're safe here with the bill, but at this point is just get everybody up to speed with what we're doing. So we have the explanation for why there's just an appropriation for the 2 new judges. Then the second sentence in that paragraph is this bill contains an authorization of 8 full-time positions, comma, 4 positions, comma, including the new judge for each district court. Can you walk us through that?
Madam Chair, members of the committee, I absolutely can. So within each district court chambers, we have 4 positions. One of them is, of course, the judge. They also have a judicial assistant who helps with scheduling and helps with notices of setting, things like that. Complex scheduling, I will tell you. They also have a law clerk. So that law clerk does research and writing for the judge. I think you heard in the interim how necessary good law clerks are for our district court judges, especially in those judicial districts where they are very busy, simply because the judges spend most of their days in court. And so in order to get those opinions out in a timely fashion, law clerks become really, really important to them. And then the final position is a court reporter. So the district courts have court reporters within each of their chambers. So those are the 4 staff members for each district court.
Questions for Ms. Butler? Senator Kolb.
I heard a noise. Thank you, Madam Chair. Yeah, this the way it's written down is pretty confusing. I mean, it leads people to go, how many people are here? I mean, the way I kind of read it about 3 or 4 times, it seems like you were breaking it up into 2 groups of 4. Is that correct? Or is that not correct?
Madam Chair, Senator Kolb, that is correct, because the appropriation authorizes 2 chambers essentially. So in the 3rd judicial district, will have 4 staff members there, including the judge. And then in the 7th judicial district, they will also have 4 staff members there, including the judge. So yes, it is split up into 2 groups of 4.
All right. Thank you.
We will make that more clear next time.
Well, it's just, there's lots of ways of saying the same thing. It's just when other people read this that may be glancing at it, it's always better to keep it more explicit to exactly what we're trying to accomplish. But thank you for the explanation.
Welcome to the Judiciary Committee. All right. Any final comments from Ms. Butler? All right, seeing none, Ms. Butler, thank you.
Thank you.
All right, further public comment on this bill? Is there anyone in the waiting room too? Come on forward.
Madam Chair, we do have folks in the waiting room, but I don't see anyone with their hand raised at
Okay.
this moment.
Okay. Welcome, Ms. Lance.
Good morning, Madam Chair, members of the committee. My name is Beth Lance. I'm here with the Wyoming Trial Lawyers Association, and we stand in support of this bill. Our members certainly have felt the delays in these courts where these new judges are desperately needed. As Judge Bumwell explained, there are certain types of cases that just have to take precedence. Obviously, criminal for a speedy trial. Juvenile cases have very distinct deadlines in which they must also be handled. And so those cases obviously take priority. And what is occurring is we're having big delays with other civil cases. For example, in Casper, where I do some of my practice, I've had to wait as much as a year for a trial date in a family law case. And certainly when looking at those kinds of issues of families and custody, that kind of delay can be really detrimental for families. And so it is important for access to justice, as you stated, Senator Kolb, that we ensure that there are enough judges in all of our districts to handle everyone's needs and get them in front of the court as they require. And so certainly we stand in support. I think this bill does a good job because it does make sense that it is only funding immediately the two where facilities exist, and it is asking to delay the funding for Gillette until those facilities are built. So I think that this bill does a good job. I think, makes sense fiscally. And certainly, obviously, we already know these costs because this is the same budget for all the existing judges, the number of employees, all of that is the same and consistent across the board. And so certainly understand that those numbers make sense and are reasonable. So we stand in support, and I would take any questions.
Questions for Ms. Lance? All right, seeing none. Thank you, Ms. Lance.
Thank you.
All right, any further public comment in the room? All right, seeing none. If anyone on Zoom or is watching would like to speak, if you could raise your hand right now. Give you a second to move quickly on your mouse.
We're not seeing any.
All right, seeing none, public comment is closed. Committee, back to you. Moved by Senator Cost, seconded by Senator Kolb. Discussion on the bill. Senator Kolb.
Thank you, Madam Chair. Just one comment. I really do look forward to electronic filing to make this whole process more speedy and to save us all money.
I didn't pay him to do that. But I will. All right. Any further comments from the committee? All right, seeing none. Roll call vote.
Senator Cooper,
Aye.
Senator French.
Aye.
Senator Kolb,
Aye.
Senator Cost,
Aye.
Chairwoman Nethercott.
Aye.
Madam Chair, Senate File 26 passes with 5 ayes.
Thank you. All right, committee, with that, we'll go to this very controversial, exciting bill. Senate File number 12, Airport Restaurant Liquor Licenses. Senator Anderson. Good to see you this morning. Welcome to the Senate Judiciary Committee.
Thank you. It's nice to be with you also.
We're thrilled to have you.
So this is kind of a complicated little bill, she said. It complicates something. I'm not sure what it is. By the way, I am Jim Anderson's from Senate District 28. What we came to find out was that the liquor licenses at the airports were seldom used and were not used very long when they were. So it seemed like a waste of our liquor licenses in the county or city, wherever the airport is located. So what they are asking to do is make those resort licenses, and the resort license does not go against your quota for liquor licenses. So in every community, that would free up one liquor license. And so there's maybe 4 or 5 communities that would do this. 3 of them for sure will do it. And I don't know if all of them have liquor licenses. All 5 of them have liquor licenses. So this is a Cody issue, a Jackson issue, a Casper issue. I'm not sure about Rock Springs, whether they have a liquor license. Maybe Senator Kolb can enlighten me on that. Gillette, I do not think has a liquor license, but they might do it if it could be a resort license. So it spreads completely across the state. The bill doesn't do much. It asks just for them to qualify. It has to be in a restaurant in a airport. The other requirement is that they can't sell liquor out of the airport or out of their establishment, which is what the rules are now in our location. We have one problem with it that I have an amendment if we could do it. Other than that, that's the bill.
Thank you, Senator Anderson. Why don't you tell us about your amendment? Is this the one from the with Ms. Urbikite and Ms. Kaiser's name on it?
Yes.
Wonderful. You support that amendment?
Did you get it?
We did.
Oh, okay. All right. So you got it.
You're with the Judiciary Committee.
Oh, I forgot. Excuse me. I
Just
forgot.
assume we know what we're doing.
Excuse me. I forgot. We set on page 2, we set line 17, 18. We set that the restaurant seats not less than 50 persons. And we found out that quite a few of them did not seat that many persons. And so we want to kick that back to 25, and then all those airports will qualify. So that's all the amendment does.
And there's also, it looks like page 3, line 8. Is that just cleanup language as to kind of how that sentence reads? It's how I read it.
Okay,
Do you have the amendment?
I do.
You want to take a minute and process it for just a second?
The premises, insert commercial service airport and delete owned and leased by licensee, which brings us to the commercial airports in the state. I don't know that anybody besides a commercial airport would have a liquor license, but cleans up the language.
Senator Cole.
Thank you, Madam Chairman. So I guess the question I have, this first work on this amendment language, the going from 50 to 25, was that something that was discussed during the interim topic was that something that was discussed where it was originally 25 and you bumped her to 50? I mean, if you could enlighten me on how that came about or why the rationale of 25. I agree, 50 seems like a lot of folks. I think maybe 30, but I don't know what the justification was. And then specifically talk about the Sweetwater County Airport. It's actually a joint powers board, 2/3 by the county, 1/3 by the city. And they have a caveat, a restriction up there. They cannot hold a liquor license now. Maybe this is a different type of license would get them out of that caveat, but they're restricted currently. That's part of the joint power. I read it myself years ago. It's like from I don't know what it was, 60s or 70s, they created this thing. And so they have a unique situation because they're actually annexed as an island out there. So their situation might be different than others, but no, they don't currently have a license to that end.
Senator Anderson.
Yes, thank you, Madam Chairman. To address the Rock Springs, maybe as a resort license, they could get that. I realize they can't get a liquor license and the reasons why, but maybe the resort license could, and maybe they don't even want one. Some of the airports do not want a liquor license. So to address the 50 was in our bill all along, and with no thought. We didn't come by that number. Somebody wrote down 50, and that's what we used. Then we started talking to the airports, and they said, "Whoa, that's too many." And they showed us pictures of their seating area. There's not 50 seats. So that's when we from our last meeting, finally we realized we needed to lower it to 25.
Follow
Follow-up.
So you see no issues with 25.
No.
That's fine by you. All
Yep.
right. And
Yep.
Okay. Well, thank you very much for explaining that.
Any questions, Senator Cost?
Thank you, Madam Chair. How does an airport go about obtaining the license, like say of Cheyenne or somebody, when they get updated, do they go through their board or their city, or how's that work?
They go through, Madam Chairman, excuse me. They go through, this is Judiciary Committee. Whoa.
I have a gavel.
Yeah, wow. Whoa. To answer your question, Senator Cost, they go through whatever municipality they're in. Cheyenne might be in the city, I'm not sure. Our airport is in the county. Most of them are in counties, but they still go through the same municipality, the same discussion, the same requirements to get the resort license. And we have a lot of these resort licenses in the state. They're at resorts. And we haven't put them in airports yet, but we hope to.
No one wants to give him a joke about the Casper International Airport? No? All right.
No.
Senator Anderson, thank you.
Madam Chairman, actually, it's the Natrona County International Airport.
It says
Stand-
judiciary.
Stand corrected.
I hesitate to correct the chairman of the Judiciary Committee, but
Corrected. All right.
thank you.
Pulling the Geneva Convention here, this international convention. All right. So thank you, Senator. Any further public comment on this bill? Mr. Mosier?
Madam Chairman,
Welcome.
members of the committee, happy to be here. Mike Mosier, Wyoming State Liquor Association. I will say that after the issue, I've been working in the Senate lobby over the last 4 days. I can safely say I've never been more happy to turn back to alcohol because this is a nice bill. I'll use an example. Things have changed a lot. Some of you are old enough or have lived in Cheyenne long enough to remember that I used to own a bar and restaurant at the Cheyenne Airport that was very busy. We were the political bar. We were a CFD bar. We did really good business. Jerry Olson, who is the field is named after, was my airport manager for many, many years. I remember one morning on Cheyenne Day during CFD, my daytime bartender and I free poured 250 Bloody Marys before 10 a.m. I mean, we did some business, but times have changed, committee. Back then, my nighttime bartender secured the Cheyenne Airport terminal. The bartender would go down, check the bathrooms, check the baggage area, secure it, lock it up, and that's who did it. And that's the way everybody did it, I assume, in smaller airports. I sold my place July 31st, 2000. September 11th, 2001, everything changed. Going to an airport was no longer going to a neighborhood bar. Over 95% of our business was locals. That's where we made our money. Now you've got a good compatriot who runs a very successful bar and restaurant at an airport in the northwestern corner of the state, but that's an anomaly. That's the busiest airport in the state. Owning a bar and restaurant at an airport is, for the most part, no longer a profitable venture just because of those restrictions. When you drink at a bar in an airport and you leave now, instead of going right to your car, you're walking by a National Guard guy with an M4 or a cop or security people, which, to use a common term, is a real buzzkill if you're planning on having a few. And so this fixes something that we wouldn't have envisioned to be much of a problem 20 years ago. We want alcohol service. Now, admittedly, most airports would be fine with a restaurant liquor license because you can serve any type of alcohol as long as you serve 60% food. But there's a few that may want to just serve beer and just chips or something. And so this is a narrowly focused bill. I think it's a good bill. Now, bear in mind, there are two bills doing the same thing, one from the House side, one from the Senate side. They're addressing the same issue in different ways. We're fine with both of them. And so if they both cross over, perhaps the good bill sponsors can arm wrestle or leg wrestle or roll dice to figure out whose bill moves forward. But this is a good bill. Now, to address the amendment, Madam Chairman, members of the committee, we're okay with the 50 to 25, but you need commercial service airport if you're going to do that. I remember when this bill first popped, a buddy of mine who works in the ag industry, and I grew up in ranch country in the Sandhills, Nebraska. Most places have airports now. I mean, you have a place to land a plane. And so you don't want this so loosely defined that if I build a hut out in my pasture with 25 chairs, I'm becoming an airport. And so commercial service airport narrows down that definition, particularly if you're dropping the number down to 25. And so with that, Madam Chairman, we support the bill. Like I said, it's narrowly defined. It helps certain airports doing something that's a lot more difficult than it used to be. And with that, I will be happy to take any questions.
Questions for Mr. Mosier? Thank you, Mr. Mosier.
Thank you, Madam Chair.
All right. Further public comment? Online? Mr. Brubaker,
Yes. Bring him in.
please. Yeah.
No. I'm sorry.
Welcome, Mr. Brubaker.
Good morning, Madam Chair. I appreciate the opportunity to speak to you. Devin Brubaker, Airport Director in Rock Springs at the Southwest Wyoming Regional Airport. I also am representing the Wyoming Airports Coalition in my statements today. And quite simply, we stand in favor of the bill and the amendment, and we appreciate Senator Anderson's leadership in bringing this forth and would appreciate your aye vote on the bill and the amendment.
Thank you, Mr. Brubaker. Questions for Mr. Brubaker? Senator Kolb.
Good morning, Mr. Brubaker.
Good morning.
I'm feeling nervous.
A question. Would you be in favor of having a liquor establishment, a bar or a license up at the airport? The question came up and I didn't want to, surmise you probably would like it, but I just wanted to hear your opinion on what you think of that. Would you be in favor of it?
Mr. Brubaker?
Madam Chair, Senator Kolb, while we are not immediately interested in this, we are in the process of modernizing and expanding our existing commercial terminal, and there will be space for facilities to support this. So in the future, it could be a very viable solution for our airport specifically. On a more immediate term, there's other airports around the state that would take advantage of this right away, including in the capital city, Casper, Cody, Gillette, and a couple others. So while we won't do it right away, there's a good chance in the future we would pursue this.
Follow up?
Have a good day, Mr. Brubaker. Thank you.
Thank you.
All right. Thank you, Mr. Brubaker. I appreciate you being here. Further public comment? All right. Seeing none, public comment is closed. Committee, back to you. All right. Moved by Kolb, seconded by Cost. Is there an amendment?
I would like to move the amendment that was presented to us by
Senator
the
Anderson?
Wyoming Airports Coalition.
Moved by Senator Kolb, seconded by Senator Cooper. So we'll read it just for matters.
Insert 25. Page 3, line 8, before premises, insert commercial service airport, delete owned or leased by licensee.
Discussion on the amendment? All those in favor say aye.
Aye.
Any opposed? That motion has passed. Back to the bill. Roll call vote on the bill.
Senator Cooper.
Aye.
Senator French. Senator Kolb.
Aye.
Senator Cost.
Aye.
Chairwoman Nethercott.
Aye.
Madam Chair, Senate File 12 passes as amended with 5 ayes.
Thank you. All right, committee, we will go to Senate File 28. Sex offender termination of duty to register amendments. Good senators, as you recall, this is a joint Judiciary Committee bill that stems from the review of Wyoming Supreme Court opinions, primarily the case Harrison versus State. I did provide you recently a memo just for your refreshing your recollections from our June joint Judiciary meeting during this interim of June of 21. So the public can find the memorandum from LSO walking through the Supreme Court opinion. It's online. But for purposes of refreshing our recollection, because it's been a number of months since we reviewed this bill and reviewed this topic, just wanted to bring it back to your attention. Committee, any discussion about the bill or comments about the bill? I think what I'll do for purposes of understanding for the public is to kind of summarize some issues in the memorandum, which are that the Wyoming legislature enacted the Sex Offender Registry Act in 1994. And the act requires offenders convicted of various sexual related offenses or certain offenses against minors to register by providing certain information to the sheriff in the county where the offender resides. So as relevant to this case, the act initially required offenders whose victims were less than 16 years and the offender was at least 4 years older than the victim to register. In 2007, the legislature amended the act to require a person convicted of certain sex-related offenses to register regardless of the victim's age. The duty to register begins at the date of sentencing and requires a person to continue registering for the rest of the person's life. Certain offenders who have been registered for at least 25 years, exclusive of periods of confinement and periods in which the offender was not registered as required by law, can seek relief from the registration requirement, provided that the offender has maintained a clean record for 25 years. And the statutory reference is 719-304 concerning the qualifications for sex offenders' obligations for termination for the duty to register. So the case of Harrison v. State, which was decided in 2021 by the Wyoming Supreme Court, the essential facts are as follows: that in 1994, Jeffrey Harrison was convicted of 4th-degree sexual assault. And under the Sex Offender Registration Act at the time of his conviction, Harrison was not required to register because it was in 1994. And as you recall, that same year that he was convicted, that was when the legislature first enacted the Sex Offender Registration Act. And so that was all kind of coming into being at the same time. And so he was not required to register, and likely was not required to register because of the type of conviction he had, which was 4th-degree sexual assault. So in 2007, his victim in that case was older than 16 as well. So 4th-degree sexual assault with a victim older than 16. But when the legislature amended the Sex Offender Registration Act in 2007, he was then required to register, and he began to do so in 2009. In 2019, 25 years after his conviction, he petitioned the court to be relieved of his duty to register. The court granted the motion, but the Division of Criminal Investigation intervened and argued that Harrison had only registered for 10 years, not the 25 years as required by the law. Harrison argued that he became eligible for relief 25 years after his conviction, regardless of the time he had registered. The district court disagreed and denied relief. Harrison appealed to the Supreme Court. So Harrison appealed to the Supreme Court, and the Supreme Court affirmed that the district court was right, that he needed to register exclusively for 25 years. Harrison argued that the enumeration of periods excluded from the registration requirement showed the legislature's intent to count periods of time after sentencing where the offender was not required to register. But the court noted that 719-304 subsection A does not say 25 years of registration shall include periods in which the offender was not required to register by law. And the court may not read words into the statute to find that it does. So the court held that under the statute's plain language, Harrison must register for at least 25 years before he can seek relief from the registration requirement. And so, good senators, the Joint Judiciary Committee provided an amendment from the duty to register in light of this case. If you look at page 2, lines 11 through 12 of the bill, what the committee has done is allowed for the counting of time to include periods where the offender was not required to register. That's the bill. Comments about the bill? Questions? Senator Kolb.
Thank you, Madam Chair. I think this is a confusing bill for people when you read it because it maybe looks differently than it is. Certainly, I can tell you I'm not soft on sex offenders or feel like they should, I don't know, get some break that, you know, they don't deserve. This is an issue that came up with the Supreme Court solely. It was worked by both House and Senate during interim topic. It wasn't just somebody cooked it up, you know, here recently. It's an issue. The issue is, you know, the date of sentencing, as I would, you know, my point would be, you know, they seem to hinge everything on date of sentencing on one part of the existing statute. Well, it seems to me, I don't know why you lose that if you had no, you know, if you had no reason to register because there was no statute in place. So then why would you be penalized for not having a statute to register with and a proceeding, you know, in a new law? So I think this is a way to address the Supreme Court ruling. This is really what it's about. There was a problem with the Supreme Court, and this is a way of addressing it cleanly and concisely. Just wanted to reiterate, I'm not soft on crime, and this is not about, you know, catching all these breaks or something. It's about something that somebody couldn't do. They couldn't do it physically. Couldn't do it. And this is a way of addressing the I don't know, the non-clarity in law. And so that's why I'm supportive of it. I think it's frankly what needs to be done. And if people would really understand this bill, I think if you had any questions about it, it becomes more clear, especially if you look at the solution to it in the new statutory change. I hope that helps. Thank you for the time to comment, Madam Chair.
Thank you, Senator Kolb. Director Shannon, welcome to the Senate Judiciary Committee. It's great to see you. Thanks for being here too on Wednesday. I know one question that came up during the interim that might be helpful to remind us of, and if you don't have the number, quite all right. But this bill draft, if this were to go into effect, this probably would only affect a very small number of offenders in the state. Is that correct? Or do you have a sense or general estimate of how many people could be affected?
Madam Chair, committee members, my name is Dan Shannon, Director of Department of Corrections. I did a review of the numbers, Madam Chair, and I think the exclusion of sentence of incarceration and then the inclusive period where the act came about in 1994, it went back to 85. We currently have 11 individuals incarcerated within the Department of Corrections that fall between prior to the 94 Act. 6 of those individuals prior to 84. I'm sorry, to 85. So that would actually affect 6 individuals potentially. We are currently supervising 383 sex offenders under form of probation or parole supervision. None of these individuals were sentenced prior to the Act of 94.
And Director Shannon, I don't expect you to know the answer to this question either, nor am I asking you to go find out. But do you know whether or not those offenders, had they even registered for a period of time, would be eligible under the provisions to be relieved of the duty to register?
Madam Chair, could you repeat the question?
Yeah, so my understanding is that in order to be eligible to be relieved from the duty to register, that you have to have only been convicted of a certain type of crime. Is that true?
But that's my understanding, yes.
And so do you know of those that are currently supervised, those offenders currently supervised, how many of them would be eligible under the statute to be relieved from the duty to register?
That I do not know now. I can get that information if you so choose.
That would take some work. So don't worry about it, Director. That's fine.
Thanks.
Senator Kolb.
Thank you, Madam Chairman. A question, kind of the way you phrased this, kind of, you left me kind of confused. So I assume this relief was granted to somebody who's completed their conviction, if so convicted, completed a parole period or whatever time you're on parole. And then the time counts from that point forward for the ability to use, to say, the statutory change. Or, you know, what is your understanding of that?
Madam Chair, Senator Kolb, individuals are required to register upon release. So the time counted prior for incarceration is not included. So take a 25-year period after such.
Yeah, so they don't get to claim the time they were incarcerated.
Madam Chair, Senator Kolb, that is correct.
Okay, I just want to make that clear for the public.
Yes.
Okay, thank you for clearing, for making me understand this better.
And my number, Senator Kolb, my numbers that I indicated before was there's actually only 6 individuals that were currently incarcerated that were sentenced prior or they were required to. So they were sentenced between 1985 and 1994 before the act came effect.
Thank you, sir.
Thank you, sir.
Director Shannon, do you have an opinion about this bill, whether or not it's a good idea?
Madam Chair, I do not. With all respect.
Any final questions for Director Shannon? Thank you for being here.
Thank you. Now.
All right. Further public comment on this bill? Another piece that this bill does, which I think is important, although not asked for, on page 3, lines 14 through 20. So currently under the law, if an offender would like to be relieved of the duty to register and they file a petition with the court, they are required to serve the county attorney in which they were convicted in the county. And that's all they need to serve. In this particular bill draft, we added the division, and that is in reference to the Division of Criminal Investigation, which maintains the record of criminal history associated with that individual. And so we also then have them required to be served as well. And as you recall in the Harrison case, it wasn't the county attorney who objected to Mr. Harrison from being relieved of the duty to register. It was the Division of Criminal Investigation who came in and objected. So essentially making them a party to the decision for whether or not an offender should be relieved of the duty to register. So kind of a unique situation there where the court did allow DCI, a law enforcement agency, to intervene on act on its own behalf without the presence of a county attorney or a prosecutor, and advocate for its own interests or its own position, as opposed to that of the elected prosecuting attorney in that region. So we have done that. I do think it's important that the division gets served, but certainly a policy consideration for this committee to consider. Senator Kolb.
Thank you, Madam Chairman. I don't know how this works. First time I've ever thought about even doing this, but I had a follow-up question that came up from Director Shannon. And I was wondering if we could clarify Director Shannon's statement, I believe, or make sure I heard this right, that you do not like this bill. And I would like to know specifically why or what in this bill you don't like. It's very important to me to hear what you'd have to say on this, Madam Chair.
Yeah, sure. Director Shannon. And if that's what you said, I'm sorry, I would have followed up as well. I thought you didn't have a position. My apologies.
Madam Chair, committee members, Senator Kolb, my response was my understanding was that Madam Chair asked if I had an opinion. I said, I do not, respectfully.
Oh, I'm sorry. I thought you said you were not in favor of the bill, and I was so interested to find out why.
Thank you.
I don't know if that's the same comment. Is it rolled up in that one? But thank you for clarification. I apologize for mishearing that. It was soft. It was very soft. I couldn't hardly hear you.
Oh, I'm sorry, Senator Kolb. Thank you.
All right, committee. Any further comments? Any final public comment? All right, seeing none, public comment is closed. Committee, back to you. Moved by Cost. There's seconded by Cooper. Further discussion on the bill? Seeing none, all those in favor say aye, or roll call vote. I'm sorry.
Senator Cooper,
Aye.
Senator French,
No.
Senator Kolb,
Aye.
Senator Cost,
Aye.
Chairwoman Nethercott.
Aye.
Madam Chair, Senate File 28 passes with 4 ayes and 1 no.
All right, with that, meeting is adjourned. Good work, senators.